Hi, welcome back to La Belle Vie. So today we have another Sarah Boone letter. I can't believe it. So it's dated August 2nd. We're going to go through it now. Essentially, it's limited to some concerns that Sarah's raising with respect to a mitigation specialist that Mr. Bankowitz has contacted to assist in the defense in her case. Now, taking a step back, just to summarize really quickly, a mitigation specialist is someone that the defense um, retains to basically tell the defendant's story, their background. And it's meant to, assist the defense, hence mitigating or helpful factors to tell the jury in the defense. So, for example, if a defendant had been a victim of child abuse, the mitigation specialist may develop a theory that includes those sad facts to kind of tell the story and maybe give a little bit more of a sympathetic light to the defendant. A mitigation specialist can also uncover things such as helpful things like, a high school teacher that thought a lot of the defendant, etc. So that's basically what a mitigation specialist is. So we're going to read the letter really quick, and then I'm going to provide some of my thoughts because I did go back through the docket because I had recalled that a mitigation specialist had at least been moved to be appointed by Mr. Bankowitz. Okay, so let's go get into the letter right now. Okay, so here we go. So you'll see it's dated August 2nd. It was uploaded onto the court's docket on August 7th. It is written to Judge Wooten. Honorable Judge Wayne Wooten, please see the included letter I received from my investigator communicating with me to provide an update on why we have been unable to meet since our last uneventful meeting with my attorney, Frank Bakowitz, on May 18th, 2023. So, real quickly here, it looks like this specialist has at least had one meeting with Sarah. That's how I'm reading her letter. My investigator also has not been able to make contact in attempts to move forward and produce very much needed and overdue progress in my case. I, as Mr. Bankowitz's client, cannot communicate with him via phone due to him still not activating one of two numbers he's given that do not work, and he keeps giving me different reasons why each time I ask to keep trying. She's talked about that a lot. I cannot fathom what the explanation for that is, and that's concerning. She needs to be able to talk to her lawyer. So I would really be interested to see what's going on with this phone. Okay, this has been ongoing for 13 months and counting. By not activating, he is actively hindering progress, compiling even greater amounts of carryover, and in the meantime, information for review when if we do actually meet in person. Last time to date was 77 days, prior to that 98 days, and 147 days prior to that date. Okay, I mean, she did see him in court in July, but that was just in court. So I think she's talking about an actual meeting. Okay, that's concerning. With the aforementioned being said, Judge Wayne C. Wooten, would you please be gracious enough to communicate with Mr. Bankowitz to supply the requested simple information my investigator needs? And we'll see in a second, she includes the letter from the investigator, what he needs, which is pretty simple. Okay, considering the number of days, weeks in between our meetings with him, and we can be working in the meantime until he is able to visit with me, his client of over a year now. Adding to the soon to be 4 years I've been already here, please see previous letter regarding all 6 of my attorneys. My innumerable attempts have been completely unsuccessful in any form of communication with Mr. Bankowitz via phone, letters, email, and voicemails attempted by an outside source. We had seen that before in one of her prior letters. It seems she has someone, a friend, attempting to contact Mr. Bankowitz. What else can I do, Your Honor? It seems my only hope is for a court date, which I'm included in, where my attorney's attendance is mandatory. Honestly, guys, I frankly think this might be necessary at this point. Again, the court has to be careful here. And I can vie for his attention during the minutes beforehand while in the courtroom. I'm sure all the allowed live cameras could provide footage of me doing so every time. I don't want to waste any more time and catch up in the courtroom is unfair and ridiculous. When can we have a real meeting? I mean, those are valid concerns. Please enable progress, Judge Wooten, not hinder. Ooh, okay. Sarah, don't piss off the judge. Justice system means we have to work together. I've got the whole world incorrectly against me already. As stated by my investigator, we are at a loss without communication in any form with Mr. Bankowitz. Thank you for your invaluable time. I'm grateful for your ethical awareness, fairness, understanding, and perspective. Activate the inactivity, please. Again, thank you. Actively seeking success in anything, Sarah Boone. Okay, here's real quick the letter that Prison Break Investigations, which is one of the third parties that has been retained both by Mr. Padilla, her first real lawyer that she had for over 2 years, and Mr. Bankowitz. So we'll get to that when we get to the court docket. But it is this company, Prison Break Investigations. So basically, they're writing to Sarah on we don't have a date here, but it looks like the court received it on 8/7. We don't know when Sarah received it. Let's see. This is when she sent it to the court. When did they send it? Looks like they sent it around the July 19th. Okay. So July 19th-ish, they write to Sarah, I received your letter. I've made multiple attempts to contact your attorney, Mr. Bankowitz, since our meeting. So again, I think that again suggests there was at least one meeting with Prison Break Investigations. But unfortunately, I've been unsuccessful. I'm not sure what's causing the issue. On May 22nd, I sent him an email requesting him to contact the jail so that I can have access to visit you and proceed with the mitigation process in person. Additionally, I sent 2 text messages to his phone on June 1st and again on June 6th, but received no response. This is what she needs. Without a letter from the attorney sent to the jail, I'm unable to visit you in person at the jail. Now, this doesn't look good. I'm at a loss until I can reestablish contact with Mr. Bankowitz. If you wish, you can write to me and I will send a letter as soon as I'm able to get in touch with him again. Okay. I wanted to take a step back. I mean, obviously this is not good. If work again is not being done that should be moving forward to get this case to trial, then that is a concern. Now, that being said, it does seem that there was at least one meeting with Prison Break Investigations, and it's been about 2 months and it doesn't look like anything's happened. That's, a concern, but again, things don't move quickly necessarily. So I'm not so sure. I think, but again, I think with everything with this particular defendant, the court just needs to be very careful to make sure that things are pursuing along at a regular pace. This doesn't necessarily mean that anything is going wrong here. Just want to make that point. But let's go back and see where we are with respect to whether a mitigation expert has been appointed in this case. So what I'm sharing here first is a motion that Mr. Bankowitz made back in February 23rd of this year for a mitigation expert. So here he says comes now defendant. She's indigent. The defense requires the assistance of a mitigation expert in preparing for defense, including interviewing and locating witnesses, performing background checks, etc. The defense requests authorization up to $10,000 at the rates established by law for mitigation expert services in this matter. So there's where he files the motion. Now, the problem is there is nothing on the docket that actually showed this motion for a mitigation expert was actually ever granted. So one reason might be that technically we don't have a motion, we don't have an order from the court granting the cost for this mitigation expert. And so just as a matter of procedure, that needs to be moved on, right? The court needs to file its order. We also know that Mr. Bankowitz currently has a motion for an additional psychologist expert for the battered spouse defense, which the JAC, which is the state agency that approves those costs for indigent defendants, as we know from my last video, they have opposed costs for that additional expert, and that hearing is actually going to be on September 8th. Mr. Bankowitz had previously mentioned September 18th, but the court docket looks that hearing will be on September 8th. So as you can imagine, we've already got Mr. Bankowitz trying to get the money for that second psychological expert. And I'm not seeing an order on the docket that this motion for this mitigation expert's actually been granted. So part of the reason why nothing's happened besides the first meeting might be for costs, right? So that could be one very simple answer. But I wanted to see kind of what else was granted around that time. Now, in the end of January, so about a few weeks before the motion for mitigation expert, Mr. Bankowitz did file a motion to incur costs for private investigator. So this is just general investigator. Now, again, some sloppiness here. She's not been charged with capital murder. She's been charged with second degree murder. But in any event, here he's filing for costs up to $10,000 for a private investigator. So they'll just be not focusing specifically on mitigation, again, trying to tell a positive story and get those positive aspects of the defense. This is just generally speaking a private investigator. And here I'll show this was actually granted on February 15th. So just before Mr. Bankowitz filed that separate motion for a mitigation expert. And it looks like a separate um, third party was not Prison Break, but this Louis Aran and Associates. They were authorized to incur up to $10,000 for private investigator services. And again, this is a PI, not the mitigation expert. So some costs have been approved. Now, I just could not find an order granting the cost for the mitigation expert. And that doesn't mean to say the court won't grant it, but that could be what's going on here is we just don't actually have the order. So hopefully that will get cleared up. But I also looked back. There was a motion for a mitigation expert previously appointed with Mr. Padilla. Her first real lawyer was working on the case. So I'm going to share that right now. Quickly, you'll see here that back on July 21st, 2021, Mr. Padilla had filed a motion to incur costs for mitigation specialist. And he did identify this individual, Katie Rain, from Prison Break Investigations. And again, that's the third party that we saw the letter in Sarah's latest letter. That's who she's corresponding with. So they are the same outfit, right? I don't know if it's the same person, Katie. That wasn't the person that was writing back to Sarah, but it is the same third party. Now, some interesting things happened. What I think happened was that motion for the mitigation expert was never granted. Then on September 9th, like a little over, a month and a half or so later, they brought this motion. This is Latin for basically retroactively, let's fix this. And so, here we said, we have these costs. We've already have Prison Break Investigations as of September 9th has already exhausted funds and needs 6,000 more for private investigation fees. Now, we don't know if that's related to the mitigation expert, but we do know that just with less than 6 weeks earlier, they had filed that motion. So I think there's potential that this motion here is basically kind of trying to clean up the fact that there was never, the order was never granted. Okay, so here's the order granting the defendant's motion for the private investigator from that August 1. So it's allowing them an additional 6,000. Again, it's Prison Break Investigations. I don't know if this is specifically with respect to the mitigation expert or not. That's hard to tell. I can't figure it out from the docket. But in any event, what we do know is that Mr. Bankowitz has filed a motion for a mitigation expert, and Sarah apparently, it looks like, had one meeting with that person and she's want to move it along, which is understandable, right? Again, we'll need to figure out more. If I were the court, I would probably schedule a status hearing sometime in this month to kind of get everyone together and really deal with some of this. But, and find out. I mean, it may be as simple as they need the motion to be approved before they can incur the costs. It may be a bunch of other reasons, or it could be that, this needs to be prodded along. I think any of those are potentially reasonable. So we'll just have to wait and see. But thank you again for joining. If you would consider liking and subscribing on your way out, that would be wonderful. I'm trying to grow the channel. And thanks again for watching, and I hope to see you in my next one. Bye.